The Zofran litigation began in late 2015. This litigation focuses on an anti-nausea medication that's been used for many, many years, but in this case it was given to pregnant women for morning sickness and nausea and vomiting. Unfortunately, the drug was never adequately tested with regard to the impact on the fetus, and there is concern that the drug may have caused a number of cardiac and cleft birth defects in children. The litigation is coordinated in the federal court system before Judge Saylor in Boston. There are less than 100 cases filed at this time. We don't anticipate that there will be more than probably 500 to 1,000 cases total that will be filed during the course of the litigation, and there's a really important reason for that. Most of the Zofran that was ingested by women or that was given through a shot was actually a generic formulation, and currently under federal law, generic drug manufacturers cannot be held liable for a failure to warn or for defects in the warning label for the medication. Only the brand name manufacturer can be held liable, and when there's a generic drug available, most doctors would prescribe the generic over the brand name. So the litigation right now is focused on the brand name manufacturers, with an exception. There are a couple states that recognize generic drug liability and have different laws than the federal law, and so only those few states those claims have been included in the litigation. We anticipate that there will probably be trials perhaps by the end of 2017 against the manufacturer, which is GlaxoSmithKline. Prior to the trials being scheduled, however, there are a number of things that need to be done, primarily sifting through millions and millions of pages of documents relating to what the drug manufacturer knew with regard to the risks of birth defects, what studies, if any, that they had completed to try to ensure the safety of the drug, as well as the manner in which the drug was marketed to prescribing physicians around the country. That process will take probably 6 to 12 months. And then in addition to that, kind of at the same time, there will also be discovery undertaken in individual cases, preparing those cases for trial. That individual discovery usually involves preparation of a plaintiff fact sheet, which is a detailed questionnaire about a particular plaintiff's family history, medical history of both the mother as well as the child, and any damages that have been sustained both by the baby as well as by the parents, including things like medical expenses, out-of-pocket expenses, nursing care, things like that. In addition to that, completion of the fact sheet, there will also be depositions conducted in the individual cases once those cases are selected for individual trial settings, which again should be probably towards the end of 2017.